I want to welcome all of you to the Fourth Circuit today. We have two interesting cases to discuss. First being Sons of the Confederate Veterans versus the City of Lexington. Mr. Strelka. Did I pronounce that correctly?
Yes, Your Honor. Thank you.
Be pleased to hear from you, sir.
Good morning. May it please the court. My name is Thomas Strelka. I'm here representing the Sons of Confederate Veterans, Virginia Division, against the City of Lexington and others. Your Honor, this case comes to you after being dismissed on a 12B6 motion for failing to state a claim. Three issues before the court, as the appellant will underscore today, are whether the enacting of Ordinance 420-205 by the City of Lexington equated to the closing of a forum. The second being whether this act by the city equated to government speech. And third, whether the 1993 consent decree was violated by the ordinance and thus rendering the appellee in contempt of court. The briefest recitation of facts at hand, in November 2010, the Sons of Confederate Veterans requested of the city the use of flag standards. These are poles that are glorified flagpole holders that are attached to lights in the city of Lexington.
Flagpole holders.
Flagpole holders.
Yeah, how tall are those things? Like 6 inches or something?
The holders themselves,
Yes.
Your Honor, factually, I'm unsure. I would imagine.
I couldn't find that in this record.
It's-
But what, you put the flagpole down in it?
Yes, Your Honor. They are.
And then, and is there a height for the flagpole or anything?
Your Honor, I'm unsure about the height of the flags utilized.
But the flagpoles aren't out there on the street all the time. When they get ready for a parade, they go out and put them in the flagpole holder.
Only
right?
the holders, which are called standards,
Is
are
that
on
your
the street.
understanding or not? You don't know, but
My understanding, Your Honor, is that there are standards, which are glorified flagpole holders affixed to light poles within the city of Lexington.
Okay.
That no flags typically fly from these unless asked for permission to fly flags through the city. It was through the permission of the city.
But they passed an ordinance that said the only flags that they're going to allow in those flagpole holders are the flag of the United States, or the flag of the Commonwealth of Virginia, or the flag of the city of Lexington, Virginia.
That's correct.
Correct?
Yes.
And you're saying they ought to allow the flag of the Confederacy?
Your Honor,
Is that what you say?
the flag that was requested of the Sons of Confederate Veterans to fly was a Confederate flag. It was not the stars and bars that we've all
There are all kinds of
associated.
Confederate flags, from my understanding of history. People, isn't that right?
I'm sorry, Your Honor.
There are lots of different Confederate,
There
so-called
are.
Confederate flags.
This one was a battalion flag. It was white, and I believe you'd have to be kind of a Civil War buff to associate it with the Confederacy. But
So that's what you wanted to fly?
that's what the Sons of Confederate Veterans wish to
Well,
fly.
that's you.
Yes,
That's you. You
That's
wanted
me.
to fly, not the stars and bars,
not the stars and bars.
but a white flag that what?
It had an emblem in the corner of the flag, Your Honor.
And what did the emblem look like?
I can't recall, Your Honor. Again, the ordinance that was issued.
Right, and they adopted this ordinance, and the point was, their ordinance didn't include your, whatever the flag looked
Exactly.
like.
Sure. It was not the United
Include that,
States.
And you say that violates the First Amendment rights
Yes,
of
Your Honor.
the Sons of Confederate Veterans
Absolutely.
of Virginia.
Yes, Your Honor.
Okay. And Judge Wilson said, no, that doesn't,
Yes, he did say that, Your Honor.
and throw you out on 12B6.
He did.
Did
He,
he find
he's-
it was frivolous?
He said he did not say it was frivolous. He said we failed to state a claim, Your Honor. We concede, the appellants concede, that the ordinance on its face is neutral. The ordinance on its face is neutral. It
You
doesn't.
concede that?
Yes, yes, we do.
Well, it doesn't, I mean, that's it, isn't it?
No, it's not, Your Honor. No, it's not. Thankfully, it's not. Your Honor, this court has held that the closing of a forum and the mechanism of the closing of this forum in this case is that of the ordinance.
Now, there's another part of this. We're interrupting you because we do that a lot. You saw what going on here in this earlier case. If they have a parade over there, you all can get in the parade, right?
Yes,
You can get in the parade, and you can march down the Main Street, or whatever street they call it,
yes,
in Lexington, and you can carry your flag.
yes. In fact, there's a
Okay, so you
permanent,
can march right down the street in the parade and carry your flag or flags or whatever you want to.
yes, but that's not the forum we're talking about.
I know, but you still can do that. They
Yeah,
didn't
of course.
do anything. This ordinance doesn't affect that.
You're right.
Okay. But you want to when they have a parade, you want to put them in the city standards.
Yes, the
And
forum,
the city owns those things.
yes, Your Honor.
And you admit that.
Oh, yes.
And they say, we're going to have them for 3 flags:
Yes, Your Honor.
the national flag, the state flag, and the city flag. You don't have any objection to any of those flags.
No, Your Honor. But the ordinance itself, though neutral, it was held in Crawford
And
versus.
those are all entities that exist right now, right? I mean, these 3 flags those.
I don't.
I mean, the Confederate States of America didn't survive past 148 years ago.
No, it did not. But the Sons of Confederacy is alive today as an organization and has regular meetings in Lexington, has used the standards before. Your Honor.
Before the ordinance was passed.
Before the ordinance was passed.
Right.
Your Honor, if you, going through the facts of the case, the
They
ordinance.
also had fraternities over at used.
Yes, and that is incredibly important. There were.
Things like that. And, right. I mean, that's the history of it.
That is how
But
we
you're
get.
saying they can't change it.
I'm
Is that
saying.
what you're saying?
I'm saying that the enacting of this ordinance, though neutral on its face, closed a public forum impermissibly.
Okay.
And that it showed viewpoint animus against
Well,
them.
it closed it not just to your clients, but to everyone.
Sure.
Except those 3 different flags that are allowed to fly. Why isn't that content neutral and reasonable? And isn't that the end of the inquiry?
No, Your Honor. First off, this court has held that a neutral ordinance or law does not mean it can't be unconstitutional. Further, inquiry into the legislative intent is not out of bounds. The Sons of Confederate Veterans were denied this opportunity.
Well,
by
how do you
having-
distinguish O'Brien? That suggests that really is a shaky terrain on which to try to gauge the legitimacy of an ordinance, looking behind a legislator's motives. So, there are all kinds of reasons why legislators do the things that they do.
Sure. Well, Your Honor, at this point in the case on this 12B6 motion, we contend that there are factual analyses that are necessary to determine the issues that the court ultimately determined, and that these factual analyses were not the court never got to that point. The litigation never proceeded to that point.
You didn't get discovery.
No, Your Honor, we never got discovery.
Okay. So that's the only relief you're seeking is a right to discovery?
No, Your Honor, we're here today to say that the district court erred in dismissing this case on a 12B6 we are saying today that we have stated a claim for relief,
Right, which will get you discovery.
which will get us to the discovery position of the case, Your Honor.
Okay.
I'm
So you
taking,
don't,
I'm taking one step at a
so
time.
you don't say we ought to rule in your favor on the merits today?
Your Honor, I don't think that is before the court. Only thing that's before the court is a de novo review of a 12B6 motion. That is before the court. Whether or not the complaint as filed has stated a claim, that's the case before this court right now.
How do you get around Kensington and our holding there that basically said, we don't look behind legislative motive on a facially neutral, behind a facially neutral budget ordinance in that case? And that was a free speech, that was a First Amendment.
Yes, Your Honor. Well, I would have to highlight the case of Joyner v. Williams, that this court ruled that it was a forum, it was a college newspaper that was closed, and it ruled that there was a viewpoint animus in determining, in examining the closure of that newspaper of why. Once the trial court was able to investigate as to what will underlie the basis of the closing of the newspaper, then it was discovered that there was a viewpoint animus in effect.
So are you saying that Kensington was wrongly decided?
I'm saying that in the current case, under 12B6 motion, we are allowed to proceed under factual inquiry under the allegations as stated in our complaint.
What kind of facts are you going to get besides trying to go at their motivation?
Well, Your Honor, under the facts of the case as we know now, we know that the other private organizations had asked for the ability to use flag standards, to use their own flags, to broadcast their own message in a non-permanent way in this forum of the flag standards, that the city had allowed up to 5 other entities that were not state or city related to use these standards.
They don't do that since the passage of the ordinance.
They don't do that since the passing of the ordinance. That's correct. But it was the Sons of Confederate Veterans who made the most recent inquiry into the uses of the standards. It was Councilman Lira who was the sole voter against, in 2010, the Sons of Confederate Veterans to use their flags in the flag standards. And it was Councilman Lira who then indicated to council that he would request a new policy be drafted to govern flags and the use of flag standards. There is no evidence that the flag, as far as selectivity or permissive use of these standards, there's no evidence that the city ever really denied anyone up to the point of this ordinance the use of those flags. It wasn't until the Sons of Confederate Veterans asked, then there was a hearing, a vote, they were allowed. Then Councilman Lira stated that he wanted to have a policy drafted. Policy was drafted several months later, and that was this ordinance, thus closing off the flag standards to use to anyone who wanted to broadcast a message outside of the United States flag, whatever it would convey, the city or state flags, whatever they might convey. The appellee has underscored an argument of government speech frequently throughout their brief, and there's one case that they go back to is the Sunum case, if I'm pronouncing that correctly. But in that case regarded a very traditional public forum, and I concede that flag standards are not, at this point, a traditional public forum. But in the Sunum case, you have a traditional public forum, and the city in that case decided not to have a monument placed in the park. The decision for the monument to be placed in the park was a request of a citizen or an organization not affiliated with the city. But the monument to be placed in the park, there was a decision by the city not to have that monument. We're not having it in the park. That court, this court, the Sunum court, held that that decision by the city was government speech, and thus we can't scrutinize government speech, and so First Amendment hands off. However, it's exceptionally important to note that in that case, the court highlighted consistently the permanency of the alteration of the public forum by having this statue that's going to be there, this monument, for as long as stone can weather the elements. There's no permanency in the instant matter. The flags were merely to be flown for a day, or that's about it for the Sons of Confederacy. They wanted to fly them during their parade on Lee Jackson Day. Furthermore, there is a very important case that has not been cited in the appellee's brief, and I highlight that there's a good reason for that. This court has adapted a 4-factor test. It's very fact-sensitive inquiry as to whether or not there is government speech, and that was in the case of Turner versus City Council of City of Fredericksburg, 534 F3D 352. It was a Fourth Circuit case from 2008. It has a 4-prong test to determine whether or not the enactment of the ordinance was government speech. The first prong is to analyze the central purpose of the program in which the speech in question occurs. The second is the degree of editorial control that the city might have over the message. The third is who's the literal speaker, and the fourth being whether the government or the private entity bears the ultimate responsibility. Now, we can go through all of those prongs. On the first, the central purpose of the policy, the displays of the flag were pursuant to requests of private organizations. And the organizations sought access to the flag standards in order to honor or commemorate their specific events. These displays were not initiated by the city in any way, and the city was not seeking to promote those messages. The second prong, editorial control, well, they didn't exercise any editorial control. There was a kind of a binary system. Yes, you can fly your flags. No, you can't. Now, they never exercised the no, you can't up until the ordinance. But as far as editing the message or having any control of what's in the message, they never exercised that before. Number 3, the literal speaker. The complaint alleges that the flags flown were those of the organization, the Sons of Confederate Veterans, indicating not only that it was a message crafted by that organization, but that the organization itself owned the flag. Now, in another case that's significant from this court in 2002, in which we were the appellant in that case, and that was Sons of Confederate Veterans, X-Rail Griffin versus Department of Motor Vehicles. That was the case that got a Confederate flag on a license plate. It was found that the owner of the item displaying the message is often considered to be the literal speaker. The owner of the items displaying the message here were the Sons of Confederate Veterans. The flag standards were owned by the city, but not the flags. And finally, as to the ultimate responsibility for the content of the speech, there is no indication in the complaint that the city exercises or even requested any control over the content of the flags. In sum, there is no basis for ruling that the complaint shows as a matter of law that the display of a private organizational flag from the standards constitutes government speech. That argument simply doesn't hold water. This case involves factual analyses that cannot be eliminated on a 12b6.
Let me ask you a question about the consent decree and your contention
Sure,
that
yes.
the city is in contempt. I mean, read literally, the consent decree essentially requires as a precondition that there be some place or event that's given over to private expressive activity. Once the activity is shut down in that manner with respect to everybody, not just your client, isn't that the end of the consent decree? And there's no basis for finding anyone in contempt of court for that.
Well, surely the forum was open to private expressive
Well,
activity.
it may have been, but I don't know that it was intended to be open in perpetuity.
Well, Your Honor, if the city has closed that forum, then it is certainly possible, in the light most favorable to the appellant in this case, that there was a discriminatory animus behind the enactment of that ordinance. We're entitled to all of those factual inferences in our favor at this point. There are more facts left to be uncovered, such as any intent that we can surmise from the council members once we get through litigation. But as it relates to the consent decree can be active or cannot be active depending upon, as you write, Your Honor, whether or not the forum was open to private expression. Our argument is that it was, and it was impermissibly snuffed out by a viewpoint animus possessed by the city.
Now, the judge who entered the consent decree was Judge Wilson.
Yes, Your Honor.
And
That
we have got some authority that says judges understand their own orders better than about anybody.
one thing that
And he's the same fellow that ruled on your case that's on appeal here, so he knows something about this consent decree. Matter of fact, he'd know more about it than any other judge.
Judge Wilson
He's
knows.
the one who entered.
Your Honor, you're correct. Judge Wilson knows quite a bit. However, it's important to know that in 1993, this consent decree was crafted from it was signed by the court, but this was a negotiated.
Well, that's what he's called a dissent decree. But
Yes.
but it was approved by the sitting district judge.
Of course.
It had to be, and it's his decree.
Yes, Your Honor.
Right, that's Judge Wilson.
And it's a
And
no.
you save some time. You got some time reserved.
Thank you.
Let's see what Mr. Carroll thinks.
Okay,
about all
appreciate
this.
it.
Good morning, Your Honors. Jeremy Carroll on behalf of the City of Lexington. May it please the Court. The questions the Court has already asked of Mr. Strelka, I believe, address the main point here in this issue, Your Honors. And that is the nature of the closure of this alleged forum. We obviously dispute that there was a forum to begin with, but even if there were a forum, it has been closed by operation of the ordinance. Mr. Strelka concedes on behalf of Sons of Confederate Veterans that the ordinance was facially neutral. And as Judge Diaz pointed out, that ends the inquiry. Under Kensington Volunteer Fire Department, which is a free speech case, as Judge Diaz pointed out, you do not explore the motivations of legislators when they enact a facially valid ordinance, or in that case, a budget amendment, budget amendment, I believe it was. Kensington relied on O'Brien. O'Brien is the Supreme Court case in which the Supreme Court held that whatever the motivation Congress had in making it illegal to burn draft cards, be it the alleged motivation that they had opposition to draft protesters, was irrelevant if the statute in that case was facially valid, was facially constitutional, and the court concluded that indeed it was. Similarly, in Hill versus Colorado, the court reached the same decision. This time it was based on abortion protesters as opposed to draft protesters. But the court reached the same conclusion, that you don't explore the viewpoint. You look to see if it's a facially neutral facially neutral ordinance, and indeed in those cases, they found that it was, and they did not explore motivation, and in fact, they have some strong language about the risks and hazards of exploring motivation.
Well, what's different about the cases that your opposing counsel cites, suggesting that in some instances the courts can look at motivation? What's the difference?
Well, most of the cases that he cites are either equal protection clause cases or establishment clause cases or free exercise clause cases. And those have a different body of law, and there is some need to explore motive the Supreme Court has held in those cases. But by the same token, the Supreme Court has been adamant that in speech-related cases, you do not need to explore motivation, and indeed this court has held the same with regard to the Kensington opinion. The Joyner versus Williams case, which Mr. Strelka mentions, was out of North Carolina Central University, and the president of the university, I believe, terminated the operation of the newspaper, college newspaper, because of some articles, I suppose, that had been published in the newspaper. The court there focused on the executive action of the president of the university. In Kensington, the court focused on the legislative action, noted specifically that it was legislative action in Kensington, and used that legislative action to distinguish from other executive action cases. Furthermore, in Kensington, the court pointed out that you don't, what you look to see is if it has an effect on anyone other than the plaintiffs, or if the plaintiffs are treated differently. And obviously, with the neutral content of this ordinance facially, it treats everybody the same. Nobody has been allowed to fly flags on the Lexington flagpoles ever since the passage of the ordinance. So it is facially neutral. It's legislative action under Kensington. It applies equally to all private parties under Kensington. And we cited Kensington in the brief because we respectfully believe it controls with regard to the motive analysis. The court, there are, and we cite in our brief, some actual, not just free speech cases, but specific forum closure cases, which refuse to explore motivation. Grossbaum, a Seventh Circuit case where excuse me, where the lobby of a city or county administration building was closed. There the court held, a facade for viewpoint discrimination, in short, requires discrimination behind the facade. Some viewpoint must be disadvantaged relative to other viewpoints. And that's simply not the case here. Middletown, another case we cited. However, it is the rules themselves which must be viewpoint neutral. The motivation for adopting a rule is irrelevant. A court in Georgia, the Gay versus Ohope, similar language. And indeed, one of the Occupy Wall Street cases in this circuit, it was a district court case down in South Carolina, held similarly. We don't explore the motivations of legislators when it comes to closing a forum. In that case, it was the South Carolina State House grounds. Two other cases that I would refer the court to, which dealt, they were sign ordinance cases, but they deal with the concept of content, Wagmore Dogs and Town of Cary. And in those cases, the only time the court deigned to look beyond the nature or the language of the ordinance was when there was a content distinction. In those cases, even though there was a content distinction or differentiation in the face of the ordinance, the court still looked at whether the nature of the distinction was because of content and determined that they were content neutral. Here, we don't even have that inquiry because facially they're content neutral and conceitedly they're content neutral. The Supreme Court and circuit courts have encouraged closure. In the Capitol Square case, which I did not cite in the brief, and I regret having not done that, the Supreme Court, is around 1995, Justice Souter, in a concurring opinion, stated, I also want to note specifically my agreement with the court's suggestion that the state of Ohio could ban all unattended displays in Capitol Square if it so desired. The Supreme Court, that was a traditional forum case. And the Supreme Court said private unattended displays in a traditional forum could even be banned if it is a facially neutral. Now that was dicta. I can see the point that was dicta, but certainly the indication is there that the ability to close a forum is absolute as long as it is content neutral and reasonable. And for the reasons stated by Judge Wilson and discussed here today, we respectfully submit that this passes muster under that analysis.
What O'Brien says is that part of the reason why we don't want to look behind legislative motive is that it is at best a hazardous endeavor But what if it was very clear in this case that the principal reason why why these flag standards were being shut down was precisely because of the speech of the Confederate Sons? Does that make it a different case?
It does not, Your Honor. Respectfully, and I would refer to the language, and Judge Wilson cited it in one of his footnotes from Justice Scalia in his concurring opinion in Conroy. We are governed by laws, not by the intentions of legislators. If the law is facially neutral, it passes muster under this type of free speech analysis and certainly under the forum closure analysis, given the cases that we've cited. The closure of the forum is not the only reason to affirm the decision of Judge Wilson. This would also constitute government speech, Your Honor. Government speech, be it the Summum case, referenced by Mr. Strelka, or the Page case, Page versus Lexington County School District, which is the case from the Fourth Circuit, which was the leading case in having to do with government speech. Those cases, Your Honor, stand for the proposition that where a governmental entity owns and controls the forum and limits access to the forum, it can then engage in speech. I don't mean all forum across the board, but if in a traditional forum such as a park, the city has the authority, because it is the speaker, and through its selection of monuments, it is speaking. It then has the authority to exclude other monuments. Then respectfully, here we submit that the city, as the speaker, these are its flagpoles. Mr. Strelka said there was no indication of selectivity, but I believe on paragraph 21 of his complaint, he alleges that Washington and Lee and VMI asked for access to those poles 5 or 6 times a year and were granted access 3 times a year. So there is some indication of selectivity on the face of the complaint. But more importantly, what he alleges is that when W&L and VMI and the Sons of Confederate Veterans and the fraternities obtained access to those poles, they had to get the approval of the city. City council passed a resolution, or city council passed a motion. City council controlled those flag standards at all times.
Did they ever deny a request?
There was as I referenced from paragraph 21, W&L and VMI requested more than they were ultimately granted. And I believe the January 2011 request by Sons of Confederate Veterans, it overlapped with Martin Luther King Day, and the city had already intended to fly the American flag on Martin Luther King Day, so their request was denied as to those 2 days.
What do these standards look like?
To answer your question, I meant to go back to that. I apologize, Judge King. Your light poles are 10, 12 feet tall or so, and the standards are 8 or so feet above head level.
So they're up in the air?
Yes.
On the light pole?
Yes, sir.
Okay.
And then the flags go off at an angle.
So the flags go out at an angle. These are small flags?
Yes, sir. Yeah, I'd say they're 6-foot flag poles that come off of the standard.
So the flags are, what, 10 or 12 feet in the air?
Probably higher than that. Probably, the bottom of them might be 10 feet, but the top of them probably 14 feet or so.
Okay.
And they line Main Street, and there's some on Jefferson and Washington Street as well, in Lexington. But the Summum case and the Page case, you focus on the identity of the speaker. Does that speaker establish the message? And does that speaker control the message? And clearly the city, through that process, even before the ordinance, of legislatively approving certain people to fly their flags on the poles, was engaging in government speech. And then I don't think it's really contested that after the enactment of this ordinance, which is being challenged, that clearly the government is speaking at all times from those standards at this point. You had asked a question about whether the Sons of Confederate Veterans could indeed march up and down with their flags. They can, they do, they have the right to. Nobody takes issue with that.
And the ordinance says that, right?
The ordinance is expressed that it preserves those private individual rights.
Nothing to prohibit individuals or curtail individuals from carrying flags in public and/or displaying them on private property.
And the 1993 consent decree came out of that type of situation where there were some people who wanted to carry flags for 150th anniversary of Stonewall Jackson's death, perhaps, or forgive me, 100, it was 100.
Wasn't that?
It wasn't that, it was something, I apologize. Maybe it was his birth, And in any event, there was some discussion about carrying the flags in the cemetery, and that's, It was that public display on public property by individuals.
It was 100 years after Stonewall Jackson died.
Yes,
Is that right?
maybe, Your Honor. I will say that is not that's not a crucial fact to this.
That's not. I don't think it is. It was 100 years ago, I believe, from the facts. Because it's just 150 years now.
Correct, Your Honor.
Because West Virginia became a state in June of 1863.
Yes, sir. So this would have been
It's going to
1863
celebrate
too.
next
So,
month, 150.
and so the consent decree dealt with private speech on the streets, private speech on private property, private speech on public property, but marching with flags. It didn't deal with flag standards. In fact, as alleged in the complaint, no private entity was ever allowed to even access those flag standards until 1994, so it couldn't have been a subject of the consent decree.
But Judge Wilson pretty much summarily denied their claim on the consent decree.
Well, I think the important point there is he made it clear that the consent decree was not intended to grant any judicially enhanced rights. The Sons of Confederate Veterans and their members have the First Amendment rights of everybody else, and this case does not present a situation where the city has violated those rights, and therefore, not only is there not a First Amendment violation, there's not a violation of the consent decree either. If the court does not have any further questions, we respectfully request that the court affirm the decision of Judge Wilson because this was a facially content-neutral, reasonable closure of a forum, if one existed, and because at all times the city was engaged in government speech when it spoke and delivered messages from its flag standards, and we respectfully request that it also deny the request to overturn the decision as to the consent decree. Thank you.
Thank you very much, Mr. Carroll.
Thank you.
Mr. Strelka?
Thank you, Your Honors. I'd like to address, Judge Diaz, your comments regarding O'Brien and Kensington a little further. In O'Brien, this established that laws regulating conduct that have an incidental effect on speech may not be challenged under the First Amendment. This court recognized that O'Brien dealt with a law that did not facially abridge speech, and found that also was the case with respect to in Kensington's budget ordinance. The instant case does involve a law that restricts expression, and so the O'Brien analysis is inapplicable. Now, there's a case I'd like to reference that's a Supreme Court case, Holder versus Humanitarian Project. That's 130 SCT 2705. In that case, in quoting another U.S. Supreme Court case, Texas versus Johnson, states that if a government regulation is related to expression, quote, then we are outside of the O'Brien test, and we must apply a more demanding standard. A more demanding standard than O'Brien must be applied in this case. This case is not one in which there was an incidental effect on speech. There was quite a monumental, no pun intended, effect on speech in this instance. There was a closing of the forum. That closing, through enaction of the ordinance, did not amount to government speech. If the court has any other questions, I'd be happy to discuss at this time.
Appreciate it very much.
Thank you.
We'll come down and recounsel and take up the next case.